I will now request Mr. Sohail Muhammad Laghari, who is the Registrar of the Sindh High Court, to please join us on stage and share his presentation on the concept of ADR Islamic Jurisprudence.
Honorable judges, guests and organizers of the event, brothers and sisters, Assalamu alaikum. My today's topic is principles of ADR in Islamic jurisprudence. The topic that I have chosen today, I would like to mention that after finalization of the events wise program, I had noticed that the topic of Islamic concepts of dispute resolution through ADR was not slotted in the panel. As such, on my request, this topic has been added at the very last moment. And only 10 minutes time have been added, for which I am thankful to Mia Shiraz Saab for arranging the event. I would like to add that I am neither a scholar nor could I study the topic in depth. But through this presentation, I wanted to invite the attention of all the learned participants and experts of ADR attending the event today that Pakistan is an Islamic Republic and the concepts of Islam are to be followed in true spirit. As such, we need to realize that our laws should be suitably amended and promulgated to contain compulsory enforcement of dispute resolution as per Islamic principles. Tolerance of dispute in Islam is of prime importance, and therefore dispute resolution through settlement in any form is termed as best of all. It is commonly understood that alternate dispute resolution has emerged and organized from Western jurisprudence. However, I would add that getting into such details, there is no doubt that it is evident in Islamic jurisprudence and history of Islam that ADR processes like negotiations, mediation, and arbitration were commonly practiced in Islam 1450 years before. And the principles of dispute resolution through such mechanism are mentioned in Holy Quran. The mode of resolving disputes among each other through such methods not only helps in bonding the relationship between the people, but it also helps to resolve the dispute once for all. Now, these are the methods of ADR in Islam. Sulh being negotiation and mediation process is foremost, and it is introduced in Islamic principles. The process of appointing a hakam as an arbitrator through the method of taqim is also found in Islamic principles. Medarab is the process of disputes resolution by combining the methods of mediation and arbitration. Then fatwa is commonly known to all and is a decision taken by Islamic scholar called mufti, which is based upon the teachings of Islam. A mufti hears the case from both sides, and then based upon such facts, he gives his decision which conforms to Islamic teachings. Now, because of the time shortage, I would skip getting into details of these principles. This is Sulh. Sulh means to an accord to end the dispute, and to end the dispute and create peace. As is literally understood, such Sulh inclines the parties towards tolerance and peace. Sulh is a joint agreement between the parties in order to bring peace in two disputing parties. Then taqim, it is a process of arbitration through which a hakam or an arbitrator is appointed by the disputing parties with the purpose to adjudicate and resolve the disputes. Taqim word literally means to entrust the dispute to a third party, being the neutral, so as to adjudicate and resolve the dispute. Taqim comes into play when disputing parties agree to appoint an arbitrator so as to settle the dispute that has arisen or is likely to arise. Then Medarab, Sulh and Taqim's combination is a process in which the parties involved will agree to solve disputes through mediation first, and if mediation fails, then the arbitration process will take over. This Medarab process is deviated from the principles of Holy Quran in Surah Al-Nisa in verse 58, which states that Allah commands you to return trust to their rightful owners, and when you judge between people, judge with fairness. Then that is fatwa. Fatwa is an opinion by a mufti or an expert. A mufti issuing a fatwa plays an effective role in finding the solution for disputes. A fatwa or opinion based upon the teachings of Islam helps in resolution of the disputes, as every right and duty is enshrined in the principles of Islam, either through Holy Quran or the Sunnah of Holy Prophet, peace be upon him. But we should understand that fatwa should be by an expert Muslim scholar. Now, I've just added few verses of Holy Quran. These verses have been read out yesterday and today, so I would skip those verses and further go on to next slides. These verses actually indicate the legality of mediation. Surah Maida verse 2 also instructs the legality of mediation. The principle relevant to the mediation in this verse enshrines that cooperate with one another in goodness and righteousness, and do not cooperate in sin and transgression, and be mindful of Allah. Surely Allah is severe in punishment. This is Surah Nisa verse 85. At this place too it has been enshrined that for a good cause every person should intervene to mediate, for which he shall be rewarded. It is further mentioned that if any person intervenes for evil cause, then ultimately he will be punished. This is verse 114 of Surah Nisa. At this place it is encouraged to bring reconciliation between the people. Reconciliation can only be possible when both parties feel that they have won, and ironically in our court system, one party is always loser and the other party is winner. The loser does not accept the losing of the battle at all costs and ultimately blames the judicial system. Therefore, such a resolution cannot be treated as reconciliation. Surah Nisa verse 35. This verse specifically relates to family dispute between husband and wife, and as we understand from simple wording that it gives principle of keeping harmony and to protect the husband and wife family relationship. But as I stated earlier that we just legislate or bring amendments to make the laws compliant with Islam without even understanding the concepts of Islam. How can our defined arbitration councils in Muslim families or ordinance will help in bringing reconciliation when we understand that there is no educational qualification required for appointment of chairman of a union council who is ultimately the chairman of arbitration council? How can he ably understand the complex situation of family dispute? I would therefore recommend from today's forum that the least we should propose is that these arbitration councils should be out of court mediation centers like Chartered Institute of Arbitrators, MICADAR, IBA dispute resolution, or any other forum where we can settle the dispute of family in an amicable manner. Now, again in Surah Nisa, verse 28, here again for settlement is focused for resolution of differences between husband and wife. Then verse 9 of Surah Al-Hujurat, in this verse 2, concept of bringing peace is being reiterated. Now after reading about these verses, then I will skip toward ahadith. Due to shortage of time, I would not be able to read out the ahadith, yet would just state that all these incidents as mentioned in various ahadith. We understand that primary reconciliation or resolution of disputes in Islam is through mediation, arbitration, reconciliation and settlement. Whereas bringing the courts in matters in the courts is secondary, it is not the primary reconciliation. Under the Constitution of Islamic Republic of Pakistan, in judicial forum, we have the formation of courts, that is High Court and the Supreme Court. We can read Article 199. It has a check that where adequate alternate remedy is available, the jurisdiction of High Courts is barred. And obviously a person cannot claim to take his matter to the Supreme Court without recourse to the High Court in ordinary manner. This is the time that we should interpret the constitutional provisions that mediation, arbitration, reconciliation and settlement through different ADR modes is also the adequate alternate remedy, not only through the principles of Islamic law being the supreme law of the land, but now it is recognized in various laws as well. Once these decisions start coming at the High Court level, ultimately these mediation centers will be facing short of space to accommodate the resolution of disputes. I will read out some of the words of Article 199. It states that subject to Constitution, a High Court may, if it is satisfied that no other adequate remedy is provided by law. As we understand, the word law has vast meaning, which extend to customs, rules, and principles of Islamic law governing resolution of disputes through mediation, arbitration, conciliation, and other mechanisms. This is one of the instances of Hijr Aswad, the black stone, when it was being placed at Kaaba. The Holy Prophet, peace be upon him, himself was the arbitrator, and because of such arbitration, a great dispute which could have arisen was avoided. Treaty of Ethiopia is focused here, from which we understand that through difficult conditions, though difficult conditions were imposed by Croatia of Makkah, yet to reconcile and reach at settlement, these conditions were accepted, which ultimately resulted in bringing the Muslims in winning positions. At this stage, as the Holy Prophet, peace be upon him, entered the Medina, he gave the Charter of Medina, wherein the rights and obligations were defined so that the residents of Medina may have peace. The concept of tolerance was given, and compromise and compounding of matters was encouraged. I would quickly state here that what we have understood is that in Islam, all these amicable dispute resolution mechanisms are encouraged in Holy Quran. The longest ayat of Holy Quran is Ayat ad-Dain, that is ayah number 282 of Surah Al-Baqarah, second chapter. This complete ayah is for borrowing, lending, and other business dealings. Our commercial disputes revolve around these dealings. It states for writing contracts requiring the scribe of such contract to maintain justice between parties. It contains directions that scribe should ensure that no one is being defrauded. Two witnesses are to be made who are then required to give true evidence, and they are directed not to refuse to give evidence when they are summoned. The period of contract need to be fixed. The quality of goods or the subject matter of the contract should be truly defined. All the disputes that we face in commercial contracts are already defined, and if we understand these principles and implement them in our commercial contracts, we will not be in troubles by bringing these disputes in courts. You can see that we find very few instances wherein commercial disputes were brought in the courts and quoted in the history of Islam. This supports the view that commercial disputes either did not arise too much or were being resolved at very inception through ADR. I would skip reading the translation and would leave to participants to read themselves to understand the principles that are given in Ayat ad-Dain. There are certain conditions for mediators that they should have qualification and should contain, these are the certain conditions that they should decide in all fairness. Now this is now concluding my presentation. I would reiterate that without going into the details of our constitutional provisions, I have focused on the preamble of the Constitution, which requires that principles of Islam with regard to equality, tolerance, and social justice. Tolerance and social justice, I repeat, have to be observed. Therefore, the very preamble requires our legislators to promulgate and amend the laws as per Islamic principles. And for dispute resolution, I would conclude that Islam gives concept of resolution through ADR as the primary dispute resolution mechanism, and we have to put blockades of ADR before taking the matters in the courts. I would also add here that it has been observed that whenever we find that cases pendency in courts have increased, we sitting at highest level bodies of national judicial policy on judiciary side and the cabinets on legislative side decide to create more courts. But we have always found that creation of more courts have not resulted in reduction of pendency of cases. I would like to quote the instance of our High Court. In the year 2009, when we were working for formation of national judicial policy, we worked out that we need at least 80 courts so as to reduce the backlog of cases. However, on the advice of the then senior judges, including Honorable Mr. Justice Mushir Alam and Honorable Mr. Justice Khilji Arif Hussain, we demanded about 158 courts from Government of Sindh, and the Government of Sindh agreed to create these courts in 3 phases in 3 years. These courts were created, and at that time in districts waste, I would quote district waste, at that time there were only 20 courts, which were increased to about 60 courts. But as I look at pendency of cases, at that time was 12,000 cases in district waste, and today it is around 20,000. So it proves that creation of courts has not reduced our backlog. This proves that this is not the solution of problem. We created thousands of posts of staff, yet our problem was not resolved. I think if at that stage we could have created only 50 court-annexed mediation centers whose administration could have been outsourced to experts like CIRB, McArthur, Karachi, IBDRF, or any other agencies, we could have achieved the goal of resolution of cases by putting blockades on institution of cases in courts. Concluding my representation, I have no words to pay thanks and regards to all participants, especially Mia Shiraz, who has provided this opportunity to me to present my viewpoints on this topic with the hope that in the next conferences they will at least provide the panel table for this topic and invite me as well to be learner further from our highly qualified experts in this field. Sir, recently they have amended Muslim Family Laws Ordinance, wherein they have provided certain definitions of Mujtahid Alam, and have again stated that family disputes are to be sent to the arbitration council. In the year 2021, December, these amendments were made, but yet we did not understand that arbitration councils are to be strengthened with learned and scholarly persons to understand the dispute and resolve them. Lastly, I would suggest that in our country, recommendations are made by various forums, yet the same are not considered. Therefore, I urge that recommendations may not be simply forwarded, but implementation board of all concerned, including that of High Court's representatives, be constituted so that all the stakeholders should follow up the process of implementation. CIRB, like any other organization, could only assemble us together and provide a floor for discussion, but they cannot follow up implementation process until we are also the members of such implementation committee. Thank you, sir.